so I make sure I don't cut anybody off.
May it please the Court, my name is Mark Peoples. I'm with the Florida Department of Transportation. With me at Council's table is Dennis Alfonso for the Pasco County Clerk. Mr. Alfonso and I would like to split our time today. We're requesting 4 minutes for rebuttal, and so if the Court would be good enough to let me know when I'm about 8 minutes into my argument, with the Court's permission, I'll yield the floor to Mr. Alfonso at that time.
Okay, so you're going to challenge the fact that I'm a liberal arts major, make me do math, huh? Okay.
We tried to make it easy on you by going with even numbers.
And I appreciate that. You have no idea. Okay, when the appellee comes, I'll ask if there's now, are there any other amicus that are going to speak? Just, okay, so then you're set, right? Yes. Okay. With that in mind, we are ready to proceed. Thank you, counsel.
Thank you. Judge, this is an appeal from an appealable non-final order certifying a class. Last week, this court handed down the Livingston v. Frank decision.
Really?
Livingston, as I know you're aware, Judge Casanueva, and I'm sure your colleagues are aware, involves basically the same facts, same legal theories, same counsel. Livingston adopted.
I would suggest respectfully that you go for it, all parties, because I have never claimed to be either omniscient or infallible.
Very good. Livingston adopted the department's arguments on standing and rejected Mallard's Cove's arguments on standing. It obviously wasn't briefed. We didn't have the benefit of the Livingston opinion when briefs were due. What I'd like to do this morning is explain why Livingston controls this case and that reversal of the class certification is required on this threshold issue. The Supreme Court in Sosa instructed us that standing is a threshold issue subject to de novo review for the class certification. By standing, the Supreme Court means a case or controversy, and it is demonstrated at the outset that the plaintiff suffered no injury and has no cause of action. Against the defendant, a class cannot be certified. Mallard's basic claim in this lawsuit is that the department and the Pasco County Clerk of Court and other clerks of court took private property from Mallard's and similarly situated plaintiffs and are therefore liable in inverse condemnation. The private property that Mallard's Cove alleges that the department and the clerk took is interest earned on deposits made by the department with the clerk of court under Chapter 74 Florida statutes. The department's main argument on this appeal is that the deposited funds were not Mallard's property. Therefore, any interest earned on that deposited funds was not Mallard's Cove's property. Therefore, there was no taking. Therefore, there is no case or controversy, no cause of action. Therefore, Mallard's Cove has no standing. Mallard's Cove takes a different view. I want to quote here from Mallard's Cove's brief so I make sure to get it right. It's a bold section heading on page 15. Mallard's has standing because it had a property interest in the deposited compensation immediately upon deposit, and the interest is separate property entitled to constitutional protection and also belongs to Mallard's. In Livingston, again, a case involving the same basic facts, same legal theory, same lawyers, this court found that the only way the provision of 74051 directing payment of interest earned on Chapter 74 deposits could be a taking is if the deposit belonged to the property owner at the time the deposit was accruing interest. This court found that the deposit was not the property of the property owner. This court found that it is the right to compensation that vests, not a right to the specific funds. This court held that the deposited funds are not the personal property of the property owner while the funds remain on deposit. Therefore, there can be no second taking. Therefore, there is no cause of action. And under the litany of cases I've just described, because there is no cause of action, because there is no case or controversy, Mallard's Cove has no standing, and this court must reverse on this threshold issue. Now, it strikes me that Mallard's Cove has a real dilemma here. Ordinarily, what any lawyer is going to do when they're faced with a case that squarely refutes their legal theory is to attempt to cabin that case to its facts, to distinguish the case on its facts. But any attempt to distinguish this case on its facts is going to run headlong into their obligation to show the other prerequisites of Rules 1.220. Rule 1.220 requires that a class have commonality, have typicality, have predominance, by which the precedent defines as one case will automatically or necessarily prove all other cases. But any attempt to distinguish one case from another case will mean that predominance can't be established, that typicality can't be established, because it's tantamount to a concession. Any attempt to distinguish on the facts will be tantamount to a concession that one case does not automatically or necessarily prove the others. And that's a segue into the department's alternative argument, which is that typicality and predominance were not established because there is the variable of waiver. Waiver, as the trial court found, is a question of fact. It's a fact-intensive analysis going directly to liability, and under the cases developed in our briefs, questions of fact going to liability defeat predominance. If there are no further questions, yes.
The legislative, would you agree that under the Constitution but the state of Florida and the Constitution of the United States, the Takings Clause, once the government effectuates the taking of the property owner at that moment in time is entitled to prejudgment interest until their claim is fully liquidated?
Yes.
Then the legislature statute 74.061, where it says that the property owner can only get interest on the amount that exceeds the amount of deposit, would arguably be unconstitutional, wouldn't it?
Could you repeat, please? I'm sorry.
Yeah. Legislature has said that interest shall be allowed at the same rate as provided in all circuit court judgments from the date of surrender of possession on the amount that the verdict exceeds the estimate set forth in the declaration of taking, which would mean the amount, in this case, since it was a quick taking, the amount that was put in. So if that's the case, and they are limiting the property owner's right to interest, arguably then, wouldn't that be unconstitutional? That's the first question. The second question, is it necessary to address that in this case, since I don't believe anybody raised it?
Nobody's raised it.
The problem is, some of these things have come up since my first oral argument, Livingston, and this one.
No.
You, counsel, are here, and I have a chance now to ask a captive audience of some of my concerns.
I appreciate it. Nobody's raised the 74061 argument.
Has anybody squarely held that, since you agreed that at the moment of the taking, interest is due, has any appellate court specifically held that, to the best of your knowledge?
Not to my knowledge.
Okay. Would that be necessary for an addressment of the issues in this case, if it's a matter of a claim, and what is the taking, or would that be collateral to?
It's not an allegation that was raised by the plaintiff, so no, I don't think so.
And you're at 7.5, so you're going to give him more time.
All right, thank you.
Hey, please, the court. Dennis Alfonso. I'm here on behalf of Paula O'Neill, who is the successor clerk to the named defendant, Jed Pittman, as co-defendant to the class, and certainly here on as appellants. And since counsel didn't use a lot of time, I don't want to outdo him by spending time. I need not do. I think counsel's point, Mr. Peoples has expressed, and it is certainly quite a bombshell. The Livingston opinion that came out certainly does address, I think, most of the moving parts of this litigation as far as Mallard's Cove. The court's ruling, as Mr. Peoples indicated, and Your Honor, as you're probably well aware, there were two components that were significant. The res judicata argument and the fact that there was no taking. In reality, the only difference between Mallard's and Livingston is how we're here. We got here through a certification issue rather than a summary judgment. None of our summary judgment rulings were final, so we couldn't come up on appeal on any of that. I don't know if this will be a significant issue, but we did bring all of our arguments concerning the merits of this case through the lens of standing And as the court and counsel have already indicated in Sosa, that's, I think, the trial court's requirement to look at the standing of the parties before we get to the constitutionality question. And I think, in all candor to the trial court and respect to the trial court, that's what happened here. I think the trial court jumped straight to the issue of the constitutional thought rather than heeding our kind of relentless arguments about res judicata and the lack of a case in controversy throughout this proceeding at the lower court level to say that this really isn't an issue that can be litigated with these parties. As far as the res judicata issue, I want to just touch predominantly on that. The underlying lawsuit, and this is fleshed out, I think, well in the briefs that have been submitted, there is no doubt in the underlying lawsuit, the prior lawsuit between the department and Mallard's Cove, there was a stipulated order of taking, stipulated order concerning the deposit, stipulated order regarding the payment of outstanding taxes from the money that was deposited in the court registry before anything else happened. It was a stipulated amended order directing the clerk how to make the payment of the deposit when it finally got there. And after all that, a stipulated final judgment whereby Mallard's effectively said, we're good, we've taken everything, this is in full satisfaction of any other claims we have, or I think under res judicata could have raised as part of this proceeding against the department. Now, I hope to just address a quick point because in Livingston, this court recognized that this concept now, and there was quite a bit of argument at the lower level about whether the clerk needed to be a party to the underlying eminent domain case in order to have the doctrine of res judicata apply. It certainly didn't in any way, shape, or form present itself as an issue in the Livingston disposition, and I think rightly so. Because in point of fact, the clerk wasn't a named party in the underlying eminent domain case, but the clerk was still addressed in all of the orders that told the clerk, get information from the tax collector about the outstanding taxes on the property. Clerk, pay so-and-so this amount of money. Clerk, receive this amount. The clerk, by virtue of its relationship to the court, performs those functions, is subject to the jurisdiction and directive of the court, and was there. So for all intents and purposes, this prior discussion we've had in many of the underlying hearings about the clerk being an essential party to this case, and that's what makes it different than the res judicata concept. Well, the clerk was already there and participating in the underlying eminent domain case. So I think we were standing in privity. We addressed the privity arguments, both, again, they were cited in Livingston and otherwise in our briefs. The other point I wanted to at least address, I think, candidly, that the issue of the res judicata and the fact there is no taking is sufficient to warrant this court, as what we would request, remand this for the trial court to continue in line with such orders as necessary, in line with the findings and the holding in Livingston. I think that's about it, but just in case this comes up, I mean, there's this issue about the class certification. We have a whole bunch of other problems that are attendant to the class certification. Certainly, the numerosity issue is one that was raised at the certification hearing. Looking at this case from the lens of this is a case that was originated in Pasco County. The Pasco clerk was the one who was joined as a party. Logically, follow this. The clerk has been effectively determined to be an essential party to this litigation. Well, the clerk, as this court is well aware, a constitutional officer is entitled to home rule protection. This goes back to, I think, the predominance and the typicality of the issues. We only have 14 cases in Pasco County, which are probably insufficient to warrant the exercise of having a class action lawsuit. The only way we get to a number that even remotely resembles something that would warrant a class action, assuming we got there past standing and res judicata, we'd have to get to a substantial number. Well, the clerk there's not that many cases. So in effect, what the plaintiffs have attempted to do here is to say, well, we're going to get to the Department of Transportation, we're going to bring in the Department of Transportation who may have cases throughout the state of Florida without joining any of those other clerks, each of whom would be otherwise entitled to home rule venue issues. And really the bilateral class certification as to the clerk is kind of this attempt to backdoor avoiding home rule venue for clerks of court. And so when you look at the number of cases that actually are at issue in Pasco County, it's 14, and those wouldn't be sufficient to warrant a class. And unless the court has any questions, I will yield the rest of my time. We'll save some for rebuttal.
Okay, thank you.
Thank you.
Good morning. May it please the court, my name is Krista Collins. I am co-lead counsel for Mallard's Cove and the class. I'm in a position this morning that in some senses is unenviable, but
I'm
in
in
a
all the
greater
positions,
sense,
well, I've never had this happen before, so don't worry.
well, in a greater sense, it's a really great opportunity and privilege to be able to directly address the Livingston order, both with respect to ownership and to the res judicata decision with this court, and also to address why the lower court's well-reasoned class certification order should be affirmed.
Does your client have a position whether or not, at the moment of the taking, which in this case was a quick taking where they put the money in, would your client at that time be entitled to interest?
No, Your Honor, because 74.061, as you pointed out,
If you were
cuts a
entitled to-
different path.
If you were entitled to full compensation and you have been deprived the use of your property, why would not the property owner be entitled to full compensation, which would
Because-
include the loss of use of their money?
Because as Caney says, the money deposited into the court takes the place of the land the moment it's deposited into the court's registry. And so the reason, the wisdom of not requiring statutory interest on the deposit itself, and I might add there's never overlap between statutory interest and the investment interest that is at issue here. But the reason there is no statutory interest on that deposit is because it is constitutionally required to be immediately available, accessible, obtainable by the condemnee. And if you look at the Phipps case, Phipps versus Watson, the Florida Supreme Court case that addresses squarely when does ownership in registry funds transfer between the depositor and the depositee, the answer is, it is the moment of deposit if the depositor relinquishes the funds into the registry and judgment of the court. And that's exactly what happens as required by the Constitution. The Constitution, Article 10, Section 6A requires property cannot be taken, private property, cannot be taken without full compensation paid or secured by deposit in the registry and available to the owner. Black's Law defines available as usable, accessible, obtainable, present and ready for immediate use. In other words, relinquished. Funds relinquished into the registry of the court. No strings attached.
Yet the
And in order-
legislature has some strings, right? You can't get the money right away because the tax assessor and collector have to be talked to first and paid first, right?
Well, here's evidence again of the relinquishment, right? And that is that once the funds are in the registry of the court, the order of taking statute, 740.12, gives the court the discretion to do what it should in its equity with respect to encumbrances, debts, liens, etc., pertaining to the property. So the court is given that ability, but the court is also has to be guided by the overriding constitutional requirement that those funds are immediately accessible. So the ability to withdraw those funds is not a privilege. It's a constitutionally protected right, and the court is guided by that overriding constitutional requirement of the money, as Caney says, taking the place of the land. And the court can make those decisions. And that begs the question, how can funds that are not owned by the condemnee be used to pay the condemnee's financial obligations? And it answers the question again, just like the statutory interest statute. The funds are immediately the property of the condemnee, whether or not they can access them immediately or choose to or not. In fact, Phipps versus Watson makes that perfectly clear, where the court says that that transfer of ownership into the hands of the depositee happens at the moment of deposit when there's a relinquishment of control, regardless of whether the depositee on the other side of it accepts it or not. The withdrawal is irrelevant. And the Webbs case is a perfect example of that. I mean, Webbs relied on Phipps versus Watson, this standard that I've described. The United States Supreme Court looked to Phipps for guidance on when ownership of interpleader funds transferred to the ultimate owners in that case, the intended recipients, the creditors of Webbs. And in Webbs, looking at Phipps, the court determined that from the moment the funds hit the registry of the court, they were private property because they were deposited for the benefit of the creditors. That's significant, I think, especially in contrast to the situation that we have here, because condomnees have an even greater right to ownership in those funds because it's constitutionally mandated that the funds be immediately available. The Webbs creditors had no right to access those funds. Nevertheless, ownership happened, the transfer of ownership happened the moment the funds hit the registry of the court.
Assuming that's correct, and that the transfer effectuates ownership, the claim in this case is that the interest generated on those funds, 90% belongs to the deposit, the property owners, right? And 10% is okay to go to the clerk's office.
We're not challenging the 10%. That is regarded as an administrative fee and a separate issue.
If it is your client's money, how can the legislature of the state of Florida take it away and designate who gets to make profits over it? It's either all your money or it's not all your money, right?
Well, I believe certainly the deposit is
your money,
all of our money.
And the interest is yours.
The cases
how can the
have-
state take 10% away and give it to the clerk?
Well, that is a very good question. I think the answer would be from the legislature, someone arguing the other side of that point is that Webbs recognizes, and 2833 was amended to deal with the Webbs opinion, but they recognize the propriety of an administrative charge for handling the fee. I'm not arguing that that's correct. I'm just saying that
would that mean that if the clerk's investment lost the money, your clients would be okay with that?
You know, my clients would be devastated, but that's exactly what happened in Phipps versus Watson. In Phipps versus Watson, the deposit was made, the depositee didn't take it out. Nevertheless, as harsh as that decision was, the mechanics of looking at that transfer of ownership resulted in the depositee being the one who lost the funds because the bank went under. Because from the moment the funds hit the registry, they were the property of the depositee. So we would be, I'm sure any property owner would be very upset if that happened. But that doesn't change the equation. It doesn't change the analysis that has to happen concerning when that transfer of ownership takes place. So I wanted to just go to the statute, the quick-taking statute for a moment, because I think understanding how the statute works also helps understand this immediate transfer of ownership. It also helps explain why what happened in the quick-taking action is unrelated to this separate piece of property, because the quick-taking action has its own rigors and procedures. So I'm sort of going to straddle to some extent between the ownership issue and the res judicata issue at this point. So the quick-taking statute requires any government condemnor who wants to forcibly acquire private property. It forces the government to specifically describe that property in the petition. And they must go through all kinds of rigors to disclose it, to make the property owner aware of it, to provide due process, and what's litigated is framed by the petition. So if you look at the petition in Mallard's, what you see is they have to designate the property by parcel. It has to be very detailed and specific. And that's what's at issue there, framed by the petition. And the final judgment is limited to the property sought through that process afforded to the property owner in the eminent domain statutes. We cited a case in the briefs. I just very quickly, I think it's the Mobile Gas case. Yes, Division of Administration versus Mobile Gas, where the court says a judgment rendered in eminent domain proceedings is not conclusive as to items of damage which were not at issue. Condemnation judgments do not preclude a subsequent claim for injuries caused by new and distinct acts of a condemnor. Well, investment interest, which is the piece of property at issue here, doesn't even exist at the time of the petition, because the interest, by definition, can't be generated until the deposit funds hit the deposit or hit the registry of the court. So at the time that petition is filed, which frames that quick taking proceeding and the rights that are going to be taken forcibly through that proceeding, the interest doesn't exist. So the government goes through those rigors, and then they must get an appraisal. They have to provide the appraisal to the property owner, and then there's an order of taking hearing. And out of the order of taking hearing, there is an amount fixed as the good faith estimate of the value of the property. And that amount has to be equal to the government's estimate, or it could be more. So, what we're really looking at in essence is a judicial closing, right? And that judicial closing in the framework of Chapter 74 has to yield to these overriding constitutional protections. And so that mechanism has to provide a means by which the government relinquishes control of the deposit so that it is immediately accessible and obtainable by the condemnee. So that's the framework. So the order of taking sets that amount, and then the government has time to decide if they like that or not. Are they willing to pay that price for that piece of property? It's not as though control ends at the order of taking. Control ends fully knowing what they're going to pay for that property, what they're going to have to deposit. The government, eyes wide open, makes a decision to effectuate that judicial closing and to consummate the transaction with the deposit. That is exactly, or mirrors, it doesn't, not exactly, but it mirrors what happens in the slow take proceeding. Because in the slow take proceeding, the government's not getting title. It's not choosing to do that, to take title before final judgment. Final judgment sets the amount. The government has the opportunity there to make that decision. If they want it, then they make the deposit. The transaction is consummated. Issues of apportionment following the consummation of the judicial closing are irrelevant to the fact that it is the deposit in both circumstances that is the quid pro quo. It is the act which closes as a matter of law that transaction. And that's the case in both. There is a case we cited in our briefs, but I want to highlight it because it directly deals with this question of whether a condemnor has any control over deposited funds once they put them in the registry. It's O'Sullivan versus Deerfield Beach. And in the O'Sullivan case, the condemnor in that instance made the deposit before final judgment, wanted to withdraw the condemnation proceeding and withdraw its funds and give the money back to the condemnee. And the court analyzed the same statutes that we've been looking at this morning and came to the conclusion that the intention of the legislature was for the deposit to consummate the closing, the transaction with finality. And it would not allow the condemnor to withdraw it. It did say if you had two parties who, both wanted to unwind that transaction that had happened, it would make sense as a matter of judicial efficiency to do that in the context of that case if they both wanted to. But absent that, the deposit represents a final, consummated transaction, and the condemnee is entitled to align their affairs accordingly. I think that's the word of the court. Again, having made that determination that it was consummated, it was closed at that moment. That case aligns with Phipps. Phipps is relied on by Webb's Fabulous Pharmacy, and all of those cases align themselves with the constitutional requirement for that relinquishment of funds and the condemnor no longer having any ownership or control over those funds when they're in the registry. So on the res judicata issue, in Livingston.
Before you go to res judicata, there's a question I've been wanting to ask, and finally have someone I can ask. Because after all, you're talking to yourself, you really don't get a different perspective. There's one other statute that comes into play here. And there's a statute that says if the amount of the deposit
Yes.
exceeds the value of the property, the government doesn't get their money back.
Right.
They get a judgment back. Does that, from your perspective, suggest anything to do with the ownership of the dollars?
No.
Or the ownership of the deposit, or whether there's a second taking or not?
No, I think that that's a statutory mechanism that is there to treat any overage as a monetary claim that can be, immediately reduces to a judgment and then can be collectible against other property other than the homestead, right? So in my view, that it confirms it's not the government's money in the registry. If it was, it would be a refund. If it was, a condomnee would have to go to the government and ask for permission on how to spend the money. The condomnee has unfettered use and control of those funds. So I don't think there has to be a mechanism for an overage, but the reality is that the condemnor has chosen that quick-taking vehicle. Eyes wide open, hired their own appraisals, came up with an amount, that decided to pay that amount, and because they wanted that property prior to final judgment, because in their judgment it was best to obtain title immediately, and when the money takes the place of the land, the government can bulldoze it if they want to. That property is theirs, lock, stock, and barrel, no limitations. And so is the money, because that's what the Constitution requires. With respect to...
You were going to res judicata.
Oh, res judicata, yes, I'm sorry.
No,
So-
when I interrupted you, I want to make sure you knew where you were.
No, I appreciate that. So in res judicata, we were able to do more fulsome briefing in this case because in Livingston, res judicata was an issue that was raised along with 20 other affirmative defenses on a motion for summary judgment. The court only ruled on ownership, didn't rule on res judicata or any of the others. And so in our brief as appellants in that case, we tackled the ownership issue, which was the court's ruling. Res judicata was raised in Livingston as a tipsy coachman issue, along with a host of other issues, and we requested leave, either clarification that we shouldn't have to brief those other issues that were raised for the first time in the answer brief, or to be given additional pages. And the request was denied, and so there was no briefing on res judicata in Livingston. The case that the court relied on in Livingston is not the controlling case. Dadeland Depot describes the fact that there are 4 specific elements that have to be considered in res judicata. There has to be identity of the parties, identity of the cause of action, identity of the thing sued for, and then the quality of the person sued. The case that was cited to the Livingston court on this res judicata issue didn't include a discussion of what those 4 elements are. It really is addressing how you analyze one of them, one of those 4 elements. But the Florida Supreme Court has said that those 4 elements have to exist. And the reason that res judicata does not bar this claim is because Mallard's Cove is seeking investment interest that was earned through the investment of the clerk. It's different property from what was at issue in the quick-taking proceeding entirely. The parties are different. The clerk is a party in this case, and that's not just because the clerk was, handling administrative matters in the quick-taking. It's because the clerk made a decision, chose to exercise the discretion to invest those funds for their mutual benefit, is what the letter from the Department of Transportation called it, so that the department could have 90% and the clerk could have 10%. The clerk made an active choice there to invest those funds. Also, that really reaches the cause of action distinction. The causes of action here are a declaratory judgment action challenging the constitutionality of 74.0514 and an inverse condemnation claim. What was at issue in the quick-taking action was the taking of private property under the quick-taking statute, and that framework So there's no alignment there. All of those 4 elements have to be present under Dadeland Depot in order for res judicata to bar the subsequent action. None of them are present here. And so as a matter of law, there is no bar to res judicata. Under the doctrine of res judicata. I want to just touch, I'm not even sure where I am on time. 20 seconds. Okay. The court's decision to certify the class, pardon me?
I'll give you a little extra time.
Thank you. The court's decision to certify the class under Rule 1.220 is reviewed under an abuse of discretion standard. And, the language in the decisions is that should be reversed if it's fanciful or arbitrary. This is a 27-page, very methodical class certification order that looks at each of these defenses, methodically considers the law. There was a full-day adversary contested class certification hearing when witnesses were called, documents were reviewed, and the decision was well reasoned, anything but fanciful or arbitrary. I might add, on the waiver question, this is why ownership is also pivotal to some of the analysis of these other issues. As a piece of constitutionally protected property, as Webbs says interest is, any waiver of that has to be knowing, intelligent, and clear. So what the court did was look at the final judgments that were submitted to her by the defendants in the case, and was able to make the determination on the face of the judgments that they didn't apply because they didn't specifically call out investment interest and in any way waive the right to receive that. And that was part of her methodical determination. So on the abuse of discretion standard, also the class certification decision should be affirmed. Thank you very much.
Thank you very much.
A couple of quick points. We'd also like to split our rebuttal time with court permission.
Oh, wait a minute. Now I've got the division.
I won't be long unless the court has questions.
I think I can do it. About 3 each.
Thank you. First of all, she intimated that the abuse of discretion standard applies to the class certification. A de novo standard applies to the department's central argument, which is that they lack standing. And that argument, as I've demonstrated in my initial presentation, is fully in accord with the recent Livingston decision. Judge Casanueva, to your question, how can the legislature give 10% of the money to the clerk if the condemner doesn't own it? It can't. The legislature used to give 90% of it to the condemner. Now it gives 90% to the ultimate ownership, but that's the legislature's prerogative. It's the state's money. And
the legislature can make a public policy statement, give the money to whoever they want to, as long as they don't run afoul of the Constitution.
Exactly. And as this court held in Livingston, the decision to give the 90% to the condemner doesn't violate the Constitution because the interest isn't owned by the property owner. If the legislature decides to give it to the condemner, decides to give it in accordance with the ultimate ownership of the funds, if it decides to give it to Great Aunt Millie, that's the legislature's prerogative. And their claim isn't that it's a good idea to give it for the interest to follow the ultimate ownership. Their claim is that it's unconstitutional to do anything else, and it's not under Livingston. Finally, she said that the condemnee has unfettered use and control of the funds. It doesn't. They admitted, and this is developed in the department's initial brief, they admitted that the clerk had control over the funds while they were on deposit, and the statute scheme itself requires them to make a motion, and the court will hear evidence on that motion and will decide to grant the motion or not deny the motion. It's not unfettered in any sense. If the court has no further questions, the department respectfully requests that this court reverse the order on appeal, finding that the class should not be certified, and remanding for further consistent proceedings. Thank you.
Your Honor, I hope not to even get close to the time that's left, but Just 2 points that I wanted to address that Mallard's identified. One, when talking about how we're straddling both sides of what to do in the underlying case, and the analogy that was provided to the court was the closing. Well, we submit to the court that the closing for Mallard's compensation of whatever nature, that closing occurred in the eminent domain case, because it was in that specific case where the court was empowered through all of its equitable powers to make certain that full compensation was addressed. Period. This suggestion that the clerk wasn't a true party or not, the issue really comes back to whether or not full compensation was made. I point out very briefly, there's a whole bunch of case law. The Constitution talks about the requirement for full compensation. Chapter 73 and 74 both address full compensation. 74 has its own built-in interest scheme of how interest is supposed to weigh into this equation. It's a general proposition that sovereign immunity is only waived to the extent it's waived in Chapter 74. And 74061 was not challenged. 74051 has been challenged. 2833 was not challenged. One last point, and I'm done unless the court has any questions. We talked about, Your Honor talked about the 2833 case, the constitutionality about the 10% to the clerk. I think the reality is the same analysis applies. If the clerk performed the taking, or the department performed the taking, it would be to the whole amount, 10% and the 90%. And the constitutionality of the 10% has already come before this court in the the Greco versus City of Tampa case, where they found the 10% fee that the clerk retained was constitutional. So we submit to the court that for these reasons, Livingston really does apply, and this court should remand for the trial court to act accordingly. Thank you.
Thank you. Thank you all. Excellent presentation. Thank you.
Thank you.
See, I could have avoided all this by PCAing it, right?
No good deed.